Hello, everybody. Good afternoon. My name is Eva Fernanda Roscon Gutierrez, and this activity is for Diplomatic and Consular Law. Activity 7, Reparations. International responsibility evokes the rights and obligations signed on the treaties and conventions between states or international organizations. It may involve citizens and foreigners, but due to the quality of being under the governance of a certain state. These international entities, states and international organizations, but primarily the first ones, are liable for breaches or keyword in their obligations when the situation can be attributable to the entity itself. Our material manages the concept of unlawful acts, which could be the occurrence of an act or omission that is applicable to a state under international law, or when it constitutes a violation of the state's international obligations. But a state will not be internationally responsible if its conduct was required by a peremptory norm of general international law, if it was taken in conformity with the right to self-defense under the UN Charter, if it constituted a legitimate measure to pressure another state to comply with its international obligations, it, it was taken as a result of a greater force beyond the state's control, if it could not be reasonably avoided in order to save a life or lives, it constituted the only means of safeguarding an essential interest of the state against a grave and imminent peril, where no essential interest of the state toward which the obligation exists or the international community was impaired. And finally, we must analyze the two elements of international responsibility, being those attribution. It is necessary that the violation derives from the acts or omissions of one or more state entities or officials. Also, for breaches committed by an individual, there must be a causal link between the act committed by a state entity and the harm caused. And the second one is breach of an international obligation. We need to delimit the obligations of each state. Studying the sources of international law, we can find rules that governs all states equally, like the customary law. But this is kind of problematic due to the geographical conditions and the absence of a legal code or regulation unifying all the states. However, with the breach of the international responsibility of a state, it comes the reparation of the violation, finding its basis on the Article 34 of the draft Articles on Responsibility of States for International Wrongful Acts, being those restitution, compensation, and satisfaction. Restitution comes from the Latin word restitutio. It means the process and the result of restituting, returning something to its original state. For example, when a person is retained or transferred to another state from his or her of origin, but the government making the breach decides to bring back that person. Then we have compensation. It can be understood as an indemnity. This refers to the act of making a payment, monetary one, to repair a damage or detriment. For example, when a state makes a breach in an economical treaty and the instrument stipulates a form of reparation as compensation, meaning this the payment of money to the affected state. And finally, we have satisfaction. This term refers to an acknowledgement of the breach in expression of regret or formal apology, among others, when the fronts mentioned above are not possible to do. For example, in the forced disappearance of a family, the state is not able to return the family, it is killed. And because it was a family, there is no person able to receive a compensation. So the state can only make a public apology and recognizes its responsibility in the crime. This actually happened recently with the situation with Canada and the Ukrainian situation. I don't know if you have seen the notices, but it happened that the Canadian Parliament gave an standing ovation to the certain officers on the Ukrainian government, but in that parliament there was a ex-Nazi official, so it was kind of problematic to make an ovation to this person. And today, the First Minister of Canada make a public apology for the situation. That's a real example, for example, of this of satisfaction. And here you have the bibliography if you want to see where the terms come from. And this is everything for my part. Thank you for seeing this.